Alright. I just want to welcome everybody. Thank you for taking time out of your busy days to join us for this awesome CLE on the Triangle Shirtwaist Factory fire and worker safety laws. Um, my name is Sylvie Manister. I'm a Decalogue board member and a member of the Women's Committee. I'm here to introduce the two fantastic speakers. We have Debbie Goldman, who earned her BA in history at Radcliffe in education and a PhD in US labor history at she's retired. She's a retired research director and telecom policy director of the Communications Workers of America, where she worked for 28 years, supporting unions, collective bargaining, organizing, legislative, and policy agenda. She advocated before the Federal Communications Commission, Congress, the Department of Justice, and state regulatory commissions in the support of the union's telecommunications policy. She is also the author of Disconnected: Call Center Workers Fight for Good Jobs in the Digital Age. Ms. Goldman also previously served as a vice chair of the board of Avodah, the Jewish Service Corps. For her service to Avodah, she received a Partners in Justice Award in 2017. She is a member of the Fabregan Havurah and Fabregan Sadaka Collective in Washington, D.C., and also serves as a treasurer of both of those organizations. In addition to Ms. Goldman, we have a previous president of Decalogue, Jonathan Lubin. He earned his BA in Near Eastern and Judaic studies from Brandeis and his JD from Chicago-Kent College of Law in 2008. He also spent a year in the Rabbinical College of America. And more importantly, he and his wife are raising 8 wonderful children in the West Watchers Park neighborhood of Chicago. He has a solo practice in Skokie, Illinois, but you're much more likely to find him at the Cigar King when he isn't giving CLE lectures. His practice areas include employment law, civil rights, commercial litigation, and he is also the co-chair of the Judicial Evaluation Committee for Decalogue. And with that, I present Ms. Goldman and Mr. Lubin.
Thank you very much. I think the way we planned this is I'm going to do the initial presentation, and then Jonathan will give his presentation, and then we'll have plenty of time for questions and discussion. So I appreciate all of you coming. I thank Decalogue for inviting me to participate. And as a point of privilege, I just want to say how thrilled I was when I got the initial invitation. My mother, Ruth Goldman, of blessed memory, was a lawyer in Chicago. I grew up in the Chicago area. And I want to just tell a little story, which as I'm looking at some of the faces, you may recollect this period, and for some of the younger people, you may not be aware of this. My mother went to law school at the University of Chicago in the class that began in 1944. Because that was World War II, they admitted some women to that class. It was a very small class. There were 20, 25 people, including my father, who never practiced as a lawyer, but that's where they met. When my mother, and in fact, in 1944, there were more women, it was about a dozen or so, women at the University of Chicago, and there were not that many until the year 1970. So it was quite a unique period. When she graduated in 1946, she was not able to get a job with a law firm. She had 2 strikes against her. She was Jewish and she was a woman. She went to work for the Joint Distribution Committee, helping the refugees coming out of the Europe at that period. And then she raised me and my siblings and went back to work as once we were finally all day in school, and she continued to practice law until she retired at the grand age of 80. And in fact, if any of you go to the American Constitution Society's annual luncheons, you will see that there is an award in her name given to a activist young woman lawyer. So That's the reason I was thrilled when I got the phone call from Decalogue. I feel like I have a lot of personal connections. Let me now share my screen so I can move into my presentation. I hope I've got the right one. I can only see my screen. Is there a way that I can also see you all while I'm doing this?
I'm not sure that you'll be able to see
I don't think I can. Okay,
not while you're sharing.
okay, so this is a very odd experience, folks, because I can't see anybody. I feel like I'm talking at into my own PowerPoint. So I hope this comes across well. I've titled the talk, Organizing the Women Workers for
Aviva,
Justice.
I'm not seeing a PowerPoint. It didn't,
You don't see it?
right?
Okay,
Am I the only one?
No, we're not seeing
Okay.
it.
okay,
Okay.
I did not share my screen properly. I apologize. Let's start again. Okay, I've got to get back to I really apologize for my incompetence with this. Okay, this should work. Share. Okay, now you should be, are you seeing it now? Okay,
Yeah, you're good.
okay, and now I've got to, and now I can even see some people, so that's more helpful. Thank you very much. I've titled the talk, Organizing Women Workers for Justice, from the Needle Trades to Call Centers of Today. And I was asked to talk first about the Triangle Shirtwaist Factory, of which we have the anniversary. It's over 110 years ago. The anniversary is this month. And I think when many of us think about Jewish women in the labor movement, we think back over 100 years ago to the organizing of the garment trades. But I wanted to bring the conversation up closer to what we're going through today. And when I was invited to give the talk, I said, I'd really like to talk about some of the things that I wrote about in my book about call center workers. And I was grateful that Aviva agreed. And so I've titled the talk, Organizing Women Workers for Justice, from the needle trades to call centers of today. But let's start with the Triangle Shirtwaist Factory of 1911. 147 women, mostly women, some men, died. The worst workplace disaster for the next 90 years, described by one historian as a crucial moment in a chain of events that ultimately forced fundamental reforms in New York and the nation. And during this period, at the turn of the century, more than half of all women garment workers joined unions, most of them in the International Ladies Garment Workers Union, the ILGWU. You see on the left the picture of the fire, women jumping from, because the doors were locked, they could not get out of the Triangle Shirtwaist Factory. Frances Perkins, who was then head of the New York Consumers League, that's her picture on the right, she watched the fire and wrote, the people had just begun to jump when we got there, she recalled. They had been holding up until that time, standing in the windowsills, being crowded by others behind them, the fire pressing closer and closer, the smoke closer and closer. Finally, the men were trying to get out this thing that the firemen could carry with them, a net to catch people if they did jump. They were trying to get that out and they couldn't wait any longer. They began to jump. The weight of the bodies was so great at the speed at which they were traveling that they broke through the net. Every one of them was killed. Everybody who jumped was killed. It was a horrifying spectacle. Perkins went on after this to join a committee to investigate what had happened. And then she was appointed by Governor Al Smith to the New York State Industrial Commission, from which she began her government service to implement workplace safety laws and child labor laws. And as most of you know, she was later appointed Secretary of Labor during the New Deal era under President Franklin Delano Roosevelt. She was the driving force leading to the passage of the 1935 Social Security Act, the 1938 Fair Labor Standards Act, which established minimum wage, minimum hours, and banned child labor. But I want to step back because there was really a context for this. We remember the Triangle Shirtwaist, the Triangle fire. But before that, just 2 years before, there had been a massive strike in New York called the Uprising of the 30,000, 1909 Shirtwaist Workers' Strike. And this shows the picture of 4 women who were young women at the time, leaders in that strike. And their life trajectory really encapsulates the activism of Jewish women for the next 50, 60 years to advocate for what one historian has labeled industrial feminism. These were all young women at the time who were born in Eastern Europe, in the small towns in Eastern Europe in the 1880s, moved to New York City at the turn of the century, went to work in garment trades, and their entire environment was rooted in the trade union movement and socialist politics of the Lower East Side. They attended a meeting in 1909 that was held at New York Coopers Union. The AFL president, Samuel Gompers, and others were there. And the men were up on stage talking to this crowd of workers. And the woman on the right there, Clara Lemlich, stood up after hearing the long speeches, and she said in Yiddish, "I have listened to all the speakers. I would not have patience for further talk, as I am one of those who feels and suffers from the things pictured here. I move that we go on a general strike." And that was really the impetus for what became the uprising of the 30,000. And the leader of the garment workers stood up and he said in Yiddish, "Let's all swear, quote, if I forget thee, O Jerusalem, may my right hand wither, may my tongue forget its speech." A quote from Jewish tradition. And all the women were familiar with that. And that led to the strike. Afterwards, there was unionization, some victories, some benefits. But as we know, 2 years later, those who were working at the Triangle Shirtwaist Factory had not won the kinds of protections they needed. And that spurred this period of activism. Let's talk then about the trajectory of these 4 women. Pauline Newman on the left. She devoted her life to working for the union. She was the first union on the ILG staff and stayed there for 70 years. But she divided her time between the union and a cross-class alliance of organization called the Women's Trade Union Unity League, which was very active for the next 40 or 50 years, a cross-class alliance which fought for the rights of working women. The middle picture, Rose Schneiderman, 4 feet 9-inch cap maker with flaming red hair and legendary speaking power. She believed in that alliance, that the most change would come between an alliance of progressive middle and even upper class women, and that was her strategy. She led the Women's Trade Union League of New York for 40 years. And she later became a lobbyist, a fundraiser, and administrator. She worked in the New Deal administration, and she was, along with Frances Perkins and others, central to passage of the National Labor Relations Act, finally establishing the legal right for collective bargaining, the Social Security Act, and the Fair Labor Standards Act. Now, another one there is Fania Cohn. She believed in education and was instrumental through the ILG and other organizations, creating a network of worker education programs, night schools, worker universities, residential colleges, lecture series, and discussion groups. And finally, Clara Lemlich-Shavelson. Very typical of many of the women at this period, she joined the Communist Party and became a neighborhood organizer of coalitions of housewives to fight for public housing, better education, and price controls. All of this is captured in one of the books I put on the reading list that I was asked to give for you all. My favorite book probably about this period of Jewish women organizing, called Common Sense and a Little Fire, Women in Working Class Politics in the US 1900 all the way to 1965. So this was a vibrant, dynamic period for Jewish women organizing. And then what happened? During the New Deal, after the passage of the National Labor Relations Act, and then during World War II, when there was the government enforced a maintenance of membership within unions, unions grew significantly in membership. And you can see on my chart here in the 1950s, 1960s, about a third of the working class were represented by unions. And at that point, remember, state and local government and federal government workers did not have the right to collective bargaining. So when a third of the workers in the 50s and 60s were in unions, you're talking about virtually the industrial, almost everybody who worked in industry, which was the dominant occupations at that point. Then in the 60s and 70s, you had the passage of collective bargaining laws for state and local and limited collective bargaining for federal workers. So there was growth there. But as the economy began to change, you saw a decline in unionization. And that really accelerated in the 80s and 90s as corporations and business began to really launch a major attack on union organization. And now we're down to about 11% of the workforce is in unions. If we were just to talk about the private sector, that would be about 6%. So this has really been a big decline. And we can talk a little more in Q&A about the corporate attack on unions and how our weak labor laws have not been able to protect the right to organize and bargain collectively. And of course, we're seeing now with this administration where he rips up the collective bargaining agreement of our transportation safety. TSA workers, 47,000 workers covered by a union contract that he just ripped up, and tried to fire the Democrats on the National Labor Relations Act. The court said you can't do that. A major attack on unions right now. And what has that meant? This is one of the charts that I think really captures what it means when you have a decline of the organization of collective power for working people, and power moves up to the benefits of our productivity and our economy are no longer shared with the working people. So you can see on the bottom graph, line of the graph, wages have basically been flat for quite a long time, the past 50 years, at least since the mid-70s, where I have that vertical line, even as productivity has increased. So what has happened is that the wealth has gone to those at the top. Here you see the red line is union membership, which beginning in the 40s, 50s, and 60s began to decline precipitously after the 70s and 80s, even as the share of income going to the top 10%, which is the blue line, increased significantly. And I think one of the statistics is most appalling is right now the top 3 or 4 billionaires, and you probably know their names, earn or have as much wealth as the bottom 60% of all Americans. So the enormous inequality. Now, we talked earlier about the organizing of the garment workers, and I said I was going to bring that a little up to date. And I bring it up to date through the union that I worked for 28 years, the Communications Workers of America. CWA. CWA began as a union of telephone employees in the monopoly era, and since then is now expanded. We represent folks in newspapers, the journalists, we represent flight attendants, we represent industrial workers, we represent state and local workers. But because the origin was in the telecom industry, one of the things I did a lot of when I was working there was both to pay attention to regulatory changes in the industry and also to assist our members who worked in the call centers, who were assisting customers and who had questions and were ordering new services or had questions about their bills. And through that, I watched the kind of experiences they had as changes increased the deteriorating working conditions in their call centers. And so I'm going to talk a little bit about that. And I like to begin with these two pictures, which shows the change. And then I'll talk about why the change. You see on the left, and fortuitously for you all, this is a picture from 1970 of what a business office in the telephone company, Illinois Bell, looked like in 1970. You can see that it was all paper records. There were no computers. You can see he did not have a headset on taking calls. There was a landline telephone, and when a customer would call in, he'd pick up the phone and answer the service. And when somebody would call up, he would go through his paper records, it was called a tub, and pull out the record of the individual who was calling and have the time to solve the problem. Now, there's one anomaly in that picture of the Illinois Bell Service rep in 1970. You see a Black man. There were very few men working in the telephone business offices in 1970. And while there were some Blacks, that was still they were underrepresented. So the reason you have this picture of a Black man is it is the only picture I could find of the paper, what the offices looked like during the era of the paper records. And most interesting, why did I find this in the National Archives records? Because in 1970, the Equal Employment Opportunity Commission, fresh with new legislation that empowered them to enforce their legislation, the largest number of complaints that they received were from people working in the Bell telephone system of discrimination. And so they levied a suit against the monopoly telephone provider, AT&T. The lawyers, as they began discovery, thought the suit was going to be about race, but discovered instead it was about gender. At that point, about 250,000 women worked as telephone operators in the Bell telephone system, and 5 men. And there were about 200,000 technicians who worked in the Bell telephone system. 5 were women. So this suit and this picture, Illinois Bell put in to the record to say, yes, we do have some Black men working as service reps, but it was very much a minority. And it's just interesting in this era to think back 50 years ago, how important the consent decree was in 1973 that opened up the technician jobs to women, the operator and the customer service jobs to men. And at least for 8 years, there were goals and that had to be met for, and this provide, and for African Americans and Hispanics to rise to management levels. Unfortunately, as we know, those kinds of programs not only are not legally enforced, they're not even voluntarily allowed now under this new administration. But I want to contrast that with the picture on the right, picture that I happened to take in 2014 when I went to a Verizon call center. And you can see there that it looks like a nice, very pleasant work environment. The woman has her headset on. She's staring at two computer screens. And but now you see that what's happened with the change, that it may appear to be quite pleasant, but in fact, the computers that are now distributing the calls are also tracking every second of what she does, how long she's on a call, the manner in which she moves through her keystrokes and her screens, when she takes her break, how long she's on a break, how many sales she makes. In fact, there's about 30 different measures of what she's doing. And because the computer has been able to track for efficiency, they've been able to squeeze out any downtime between calls, one after another. And if their queue for waiting is too long, she starts getting notices on her computer. Get off the phone so you can take the next call. This explains why we all grit our teeth when we have to call a call center because of what's going on. So a job which gave satisfaction and autonomy to the service representatives before the age of competition has now deteriorated into this kind of a job. The really major change that precipitated this was the breakup of the Bell system in 1984. And this was the result of a change that historians call the decline of what was a New Deal consensus, that there was a value in regulatory oversight of our market economy to protect against the worst abuses, as well as an understanding that we needed to have collective bargaining as a countervailing force for the power of business and corporations in our society. Well, beginning in the 1970s, that consensus began to break down. And the idea was instead to institute competition and deregulate our economy, whether it was telecom, trucking, airlines, or finances, and let competition drive price decreases and innovation. But what happened instead was a race to the bottom. And this particular chart shows a massive change that occurred in the lives of the people who were working at customer service. After the breakup of the Bell system, then the AT&T of that time could only provide long distance service. And there were 7 local Bell companies, they called them the baby bells, that provided the local service. Well, AT&T had to set up a whole new customer service operation, and they were in a very competitive environment. They came to the union and they said, we cannot compete with, at that point it was called MCI and Sprint, anti-union companies, new entrants. They had new high technology. They said, we cannot compete with the wages of these non-union companies. And if you want to, a CWA, represent these 13,000 new customer service people that we're going to hire, you need to agree to a 20% wage cut. And if you don't, we're going to contract out the work. Now, that's a kind of choice that many unions have been faced with in the past 20, 30 years. And what does a union leader do? In this case, the CWA leaders agonized and said, we'd rather be able to represent them and try to bargain up their wages, but then have to organize them from the outside. So they agreed. And you can see with the red line here that the AT&T account reps' wages were about $10,000 less, even 20 years later, than the folks at the local Bell companies who did not have to accept that wage cut. So the downward pressure on wages as you have competition between union and non-union companies. The other impact, as I said, was at the Bell system. the local companies where they couldn't insist upon a decline in the wages. And so instead, they used the new computer technology to squeeze labor costs by making people do more with less. And they could track how many calls come at 10:35, at 10:45, at 10:50, and schedule people so that they were meeting that demand with no time in between. When you have that kind of a speed up, it means that you've got to have people adhering to their schedule, or else you're not going to have the right number of people scheduled to meet the demand. Of course, demand does fluctuate. And so the companies imposed a new policy called adherence. And this was crazy because what it meant was if you were on the phone as a service rep with a customer at 10:30 and you needed to finish the call, but you were supposed to go on your union negotiated break at 10:30, you'd stay on the call. Your whole purpose and meaning in your job was to serve the customer. Well, you were then out of adherence. And if you then took your 15-minute break and came back at 10:50, you were out of adherence again. And our members were getting disciplined for this kind of being out of adherence, which to them meant they were providing service to customers. They came to the union and they said, we need to rally against this. We want a national day of protest against adherence. And this particular slide shows one of the stickers that was used or the flyers that was used. Adherence is sticking it to the worker. And she says, I'm sorry, sir, but due to adherence and the monitoring and the sales quotas, I have no time in my daily schedule to help you. That's what it felt. This produced, and this is one of my favorites, a local in Ohio made a coloring book, and the manager is holding a catheter and says, now I can't make you wear these, but it sure would help with adherence. So what was going on, and this brings us to the topic of health and safety, was a different kind of health and safety challenge for the workers. The challenge was stress. People were feeling enormous stress. And in 1997, CWA took a survey of our customer service representatives. 66% told us that they had stress-related illnesses, migraines, depression, high blood pressure, etc. A third told us that they were taking time off work due to stress-related illness. And 10% of this group said it was as much as more than 1 month. They said the call centers had become an electronic sweatshop, kindergarten, workplace from hell. So this was the kind of situation that had turned what were considered pretty good jobs, albeit paternalistic, albeit very regimented by all the rules of the Bell system. But once it gave the workers a sense of some degree of autonomy to do what they wanted to do, which was to serve customers. And they had become this kind of stress. There was really a stress epidemic in the call centers. So how did the union respond? Well, if part of what's driving these terrible working conditions is the competition from the non-union companies, then you go out and you organize. And on the right, you can see that a group of, at that time, they were called customer agents at Sprint, which no longer exists, but at that point, it was a long distance company, then became a wireless company, and then was bought by T-Mobile a couple of years ago. But at that point, they tried to organize a union. And there were dozens of call centers around the country. And as a more significant group of employees at any one call center was discovered by management, which was spying on them, discovered that they were organizing, they would shut down that center and move the work. One of the most likely places for a victorious Union election was out in San Francisco. There was a small call center of Spanish-speaking folks who telemarketed to a group of telemarketed to Spanish-speaking people in the United States who made a lot of calls to Mexico and Central America. They had terrible working conditions. They were told not to drink water because then they have to go to the bathroom. They would be working on a commission, and then as soon as people were getting close to that commission, they'd raise the sales quotas. And this group came to CWA and said, we want a union. And almost everybody signed a public notice that they were going to vote for the union. A week before the union vote, Sprint closed the center down and by a flick of a switch, moved the calls to Dallas. Well, CWA decided that they were going to try and save these jobs for these women because it's illegal to close down a workplace just to avoid a union. And the most interesting aspect of this campaign was when the Mexican Telephone Workers Union filed a complaint under the NAFTA labor protocols, saying that the US was not enforcing its own labor laws. Ultimately, that did not go anywhere. Ultimately, the courts ruled that the shutdown of La Conexión Familiar, as it was called, was for economic reasons. This despite the fact that they had also levied 50 unfair labor practices against them. But this is an example of what happens under our very weak National Labor Relations Act, that it's almost impossible if an employer wants to block unionization. Even if they violate the law, the penalties are so small. And if you shut it down or fire people, you instill fear. The choice is a job or a union, not a choice of a union or no union. And so CWA and many other unions in the more recent period have chosen a different approach for organizing. And that is to use whatever kind of community and regulatory leverage we can to get an employer to agree, okay, we will be neutral. We will not fight the union. We will let the workers decide, free of fear and intimidation, whether they want the union. And that's what happened in the southwestern part of the United States at Southwestern Bell. CWA saw that telecommunications was changing and that the growth was going to be in the wireless and the internet, the data side. And those were subsidiaries that were the companies were forming outside of the union representation. And so for 5 years, the folks down in Texas, Arkansas, Oklahoma, Missouri, that area, were organizing and helping the wireless employees who were non-union organize to get a union. And after 5 years, including using some regulatory changes when Southwestern Bell wanted to buy Pacific Telesis out in California, in order to get that approval, they came to CWA and said, will you support us as we go before the regulators in California and at the national level? And CWA said, what's in it for us? Will we grow? And at that point, wanting to get the support of the union, Southwestern Bell said, we will be neutral as you organize the wireless workers. And that led to the organization of the wireless workers. Every time this growing company, SBC, bought another telephone company and eventually bought AT&T and renamed itself AT&T and became AT&T Mobility of today, the workers in the company that was purchased had the opportunity without opposition to join the union, and they did. And at one point, you can see on this chart, 45,000 wireless workers were represented at AT&T Mobility. It's the only union wireless company were represented by CWA. And you can see in the chart also that then one of the cost savings, and you're all familiar with this, I'm sure, is the beginning of the outsourcing and offshoring of call center work. And I'm happy to talk about that in the Q&A. I'm going to end this talk on a high note, which is always important because it's important to know how the women, primarily women, who were working under these incredibly stressful conditions, we were making incremental progress in getting protections against the worst abuses of speed up and of monitoring and of sales quotas and adherence. But the companies were continuing these practices. And the women, who were primarily women in the call centers, mobilized their strength to elevate their concerns about stress, to make this in the year 2000 a strike issue. And in the year 2000, 67,000 union members at Verizon, in the area from Maine into West Virginia, went on strike for a variety of reasons: job security, organizing rights, and relief in the call centers. And this is a picture from a New York Times article. May I Help You became a labor issue. And the stress and the conditions in the call centers were elevated. And in fact, after the strike, the union won even greater protections against the abusive monitoring, adherence, and sales quotas, but especially they won 30 minutes off a day where they could get off the phones and research and call back customers, which was a huge thing. Now, what I've been talking about, this kind of use of computer monitoring, is not unique to the phone industry. You've read about this at Amazon, the warehouse workers who are tracked as they pick things and put them to go out to customers who've ordered them, the kinds of time constraints they're under, the Amazon truck drivers who it came out where the time quotas were so intense that there were pictures of people who had to bring Coke bottles into their trucks because they didn't have time to go to the bathroom. And even white collar professionals during COVID, as people came home, there became a whole industry of software to track, to make sure that people were actually working on their computers when they said they were, and could see what they were doing and count their keystrokes, etc. So this is not new. Stress as an issue now in the modern workplace is a health and safety issue. The result of all of these policies, you can see what's happened to union density in the telecom industry, a dynamic industry. While the number of workers has gone down somewhat, what's really declined is the percent that are in the union, which illustrates the challenges of representing under our current weak labor laws. I hope this has intrigued you enough that you might be interested in reading more of the detail about both call center workers and the context of the changes in our economy from the New Deal order to the neoliberal order today. And if you're interested, you can order the book from the University of Illinois Press. And I encourage you to use the discount code F24UIP so you can get a good discount on the book. Again, University of Illinois Press, Disconnected. And thank you. And I know that we're jumping now to Jonathan to hear about contemporary issues with representing workers as individuals. And I'm happy to talk about any of these topics during the Q&A. Thank you.
Okay. Good afternoon. I'll try to jump through this to make up some time. But my first, okay, so what I'm going to be talking about is not so much while on the job, if there is an issue that has to do with safety or health or something like that, what I'm going to be talking about is what happens afterwards when the client gives you a call and says, "Hey, I was terminated from my job for complaining about a safety issue or a health issue at work, or they're making me do something which I think is unhealthy or unsafe. What exactly do I do?" And something that you'll find in each of these cases is that in those areas which are regulated, and of course, almost everything is regulated to some extent at this point. So in those areas which are regulated, the regulations are going to be very specific. And there are very few lawyers that know all the regulations about a specific industry. So in general, you're going to get a lot of education from your clients about what the specific regulations are in the industry. And your job kind of is to be the generalist that understands employment law, or at least that's what my job is. So my first case, I think my first case ever, I don't remember whether there was two of them, but I was right out of law school in 2008. If anyone that remembers 2008, it was not a phenomenal time to be looking for a job. I was working for Lonnie Ogus as a clerk. If you know Lonnie, you know he's the best mentor a person could possibly have. But I was basically a law clerk with a law license, and so he came into my office and he said, you should start taking your own cases. And so when I did that, one of the first cases that came in was this fellow by the name of Lance. Lance is a trucker, and there are a lot of rules in the trucking industry having to do with hours, right? You don't want to have truckers that are driving, 24 hours a day and are falling asleep at the wheel, because that could be a safety issue for them and for the people around them. And so, Lance, as he put it, grew up in the school of hard knocks. He talked like a trucker, which, by the way, is pretty similar to how attorneys talk. But the story was that there was a specific exemption to the general hours laws, and this is something he explained to me. He had to explain this to me, and then I had to go look it up. You got to fact check your clients, but he's the one that pointed it out to me. I didn't know anything about this. But there's something called the short haul exemption. So in other words, there's a different standard if a person is leaving from New York and driving to Chicago or driving to LA. There's a different standard than if you're leaving from, let's say, a place in Chicago and you're returning to the very same place. And so the specific exemption is, not that it really matters too much, but the specific exemption is that you're exempted from the typical hourly requirements if you operate within a 150-mile radius of home base, and if you return to home, if you start a home base and return to home base within 14 hours. Okay, so this allowed him to be exempted from some of the hour requirements. And what happened was he's coming close to the end of his day and he's on his way back to home base, and he gets a text message on what at the time was called a teletrack. I don't know if they still use that, but a teletrack basically is text messages. So he gets a message on his teletrack that says, "Could you pick up one more, can you pick up one more load?" And he says, "If I do that, I'll be beyond the number of hours I'm allowed to work under the short haul exemption." And so they said, "Well, just stop off at an inn or something like that." And so he says, "Well, if I stop off at an inn, then I don't comply with the short haul exemption. And it's going to be my license at the end of the day. If I lose my ticket, then there goes my ability to make money for myself and my family." Same thing for lawyers, by the way. And so I know I'm not going to do that. And they respond, and I had the text messages. They respond, "Why do you always do this?" Best case ever, right? And then he gives them a call, or no, I think they called him. I don't know who someone called. One of them called the other, and my client Lance said something along the lines of, "This is bullshit." And so naturally, he was terminated the next time he went into work for using foul language. Okay, so this is where most attorneys pick up their case, is after the bad thing happened. And so what we did was we went to OSHA. We filed a complaint with OSHA, and I think one of the handouts is some of the requirements for filing a complaint with OSHA. But that's a thing you can do. And basically the complaint was that he was terminated he was retaliated against for requiring that they follow the laws having to do with safety and having to do with health. Okay, great. So I was spoiled from this case because I thought, oh, all the cases are going to be like this. All the evidence is going to be like laid out. When the client comes in, I got the teletrack with them saying, "Why do you always insist that we follow the law?" And the letter firing was even better. It says, "You're terminated for foul language and for insubordination." Okay, well, insubordination, it's pretty clear what that meant. I made my first mistake in agreeing to a settlement conference at the at home base and at the employer. I haven't done that since. It's a bad idea. When I was a young attorney, I didn't know anything. And so I drove all the way down to this place somewhere in South Chicago and with my client. And it was a conference room in there. And I sat down. And then I made my second mistake as a lawyer in a settlement conference, which is I gave them what the actual damages were. And they said, okay, well, how much you want to settle for? And I explained it. I had my, my little graph. And I said, here's the number of hours he would work in a week, and here's his hourly wage. And so the amount of money he's out at this point is this amount, and that's what we want. Everyone knows now you got to go in and say, pain and suffering, $200,000, whatever. That's not what I did. I said, he's out $42,000 on the dot. And the employer came back with, if I recall correctly, I think they came back with 3,000. And so I said, all right, well, when you're willing to talk, I'm happy to talk with you. And I got up and I walked out of the room. The attorney for the company came running down the hallway, and he says, all right, 13. I said, okay, I can start with that. And then we negotiated, and it was great. I was really spoiled. I thought the rest of my practice is going to be just like this case. Everything's so simple. All right, so let's talk about what the laws actually are in Illinois. There are two in Illinois. Federally, there's of course there's OSHA, and what you will find is that in a given industry, as long as it's regulated federally, which most are on some level, there may be a cause of action for retaliatory discharge or for retaliation specific to that industry, which is spelled out somewhere in federal statute or in the regulations. And normally, it's going to be OSHA that hears those cases. But it isn't always. So, industry by industry, you kind of have to look out for if they have their own system. Sometimes the problem with the system is that they do an investigation, but they don't necessarily guarantee you a hearing. And of course, as an attorney, you really want a hearing. So the best place to go in the vast majority of cases is state law. And since I'm in Illinois, we're going to talk about Illinois law. And so that's why I wrote at the top of my handout, start from the beginning, or when in doubt, start from the beginning. It's in order to analyze any employment case, whether it's retaliatory discharge or whether it's discrimination or any other case. Someone calls you up with, I was terminated and I don't think it was right. You always have to start from the beginning. And the beginning is that employment is at will. At common law, employment is at will. A nice little quote from 1884 that was cited in the Palmatier case, which is kind of explains the contours of what became the retaliatory discharge claim about why it is that that employment is at will. But basically, in Illinois and in every other state, employment in general is at will, other than the exceptions. And so, the exceptions: discrimination on the basis of race, religion, sex, sexual orientation, gender identity, and so on and so forth, national identity. And so the other one is when the termination violates public policy because it's a retaliatory discharge. So it came out originally from the workers' comp statute, and the first retaliatory discharge claim was basically a workers' comp claim. I see there's a message coming in. Okay, cool. Was a workers' comp claim, right? A person files a workers' comp claim, and he's terminated as a result. And so, the first retaliatory discharge cause of action that was recognized was you can't do that. You can't terminate someone for filing a claim under workman's comp. This was expanded somewhat in Kelsey versus Motorola in 1978, and then the contours of it are spelled out in Palmatier versus International Harvester Company. And so what it did in order to, I'm normally more interested in what the law is than the theory, but the theory can be kind of interesting, particularly in this area, because it informs what the law is. And so the way that decision reads, and it's really kind of an interesting read because it's a history lesson, but it goes over in other jurisdictions and in Illinois, but mostly in other jurisdictions, areas in which there is a recognition that the at-will employment standard is not helpful. That there needs to be some accounting for example, if someone has jury duty and they need to go to jury duty. So you don't want companies to be firing their employees because they're not refusing to go to jury duty and getting in trouble. And so it goes through a number of examples of it: perjury, price fixing, consumer credit code, things that affect, and the thing to look for in all of these is things that have to do with public policy. In other words, it wouldn't be good public policy to require employees to do things that are going to injure people in general, people at large, not necessarily the employee himself, but to injure the public. For example, practicing medicine without a license. You know, it wouldn't be good to allow companies to terminate someone for refusing to engage in things that violate public policy. On the flip side, of course, you know, start from the beginning, employment is at will. And so anything that has to do in general with the employee's own life at that point generally wasn't protected. And so there's a number of examples that are given there. For example, the employee wanted to attend night school, and so on and so forth. And then the decision identifies a couple of areas where courts go different ways in different jurisdictions. And so then it codifies this general idea of a person can't be terminated for doing something which violates public policy, and public policy is then defined as something which is recognized in state or federal statute or in regulations. So, okay, so in other words, if someone is at least at this point in the law, now we're talking about the 1980s, if a person is refusing to do something that he believes is perhaps unhealthy or perhaps unsafe, if there isn't a statute about it, you may be out of luck. And that's been expanded on to some extent, but when, you know, every time one of these cases come in, there are not a ton of them, but every time one of these cases comes in my life, that's kind of where I have to start, is figuring out, okay, what is the public policy at issue in this person's circumstance, and can I find it in a statute? Can I find it in a regulation? And you know, the big practice tip here is your client in almost every circumstance is going to come in with some understanding of what the regulations are that affect their industry. And so your client becomes your best research assistant in explaining, you know, the specifics and the contours of that particular industry. So I've had a few of these. You know, one had to do with a bus driver who didn't like the way the kids were crossing in front of the bus. And you know, she was able to find that here's the regulation about how this, you know, how the bus driver is required to tell the students, you know, don't cross this way in front of the bus, cross that way in front of the bus. And every time she would complain about it, you know, she'd be told, look, don't make waves, don't make noise. You know, the parents don't like it. They don't like you complaining about their kids. You know, you got to do your job and come home. But that's always where that's almost always where you have to start is finding the public policy as it's spelled out in statute. As you can see in some of these, and I'm not going to go through the whole thing, but as you can see in some of these, it's been expanded to some extent. The most recent decision I was able to find from the Supreme Court, of course, is Roberts versus Board of Trustees of Community College. And there too, by the way, you'll see there's a similar language that in general, you know, you kind of need to look for the statutory basis, or at least some basis found in case law, for what the public policy is, because public policy is a pretty open-ended concept. All right, fine. So that's that. And now we're going to move on to the Illinois Whistleblower Act. This was passed in the 90s. There is some case law about the extent to which the Whistleblower Act has subsumed retaliatory discharge, and it hasn't. They both are they're separate concepts. There is quite a bit of overlap, but there's not total overlap. And so if you have a case and you look at the Illinois Whistleblower Act and you see, well, I don't really have a case under the Illinois Whistleblower Act, but you do have a case under the concept of retaliatory discharge, you may be in luck. The difference, of course, is the damages and penalties under the Illinois Whistleblower Act are better. And there's, you know, since it's more spelled out in statute, you know, you get specific penalties, and there's injunctive relief and so on and so forth. But in as much as the retaliatory discharge concept comes from the Workman's Comp Act, there is a provision for attorney's fees in the Workman's Comp Act. So that's always a good incentive to defendants to settle a matter. Okay, fine. So let's quickly go over the Illinois Whistleblower Act, and then I will be done. So the Illinois Whistleblower Act really has to do with, as the name implies, whistleblowing. It has more to do with that than to do with specific refusals to engage in behavior, but there is the catch-all. So, okay, there's section 1, the statute is 740 ILCS 174. So it's sections 15 and sections 20 that give you the cause of action. So 15 has to do more with it has to do more with disclosure. And then 20 is the one that has to do with refusal to engage in any act, which would be a violation of state and federal law or regulation. And take a look, by the way, at the difference, because the difference is important. In 15A and B, which deal with disclosure, so the act prohibits retaliation against an employee for disclosing or threatening to disclose to, and there's a list. It's a different list than A and B. That's why I put them together. I just put it all together. So it's a public body, meaning a regulatory agency or a court. B deals with law enforcement and that type of thing. So if someone, if a police officer is coming around and asking questions and you talk to the police officer, yeah, I think there may be something funny going on over here. So there, it's the employee just has to have a good faith in order to be protected. The employee just has to have a good faith belief that the practice in question violates state or federal law or regulation or poses substantial and specific danger to employees' public health or safety. So you see that there is a recognition within the statute for something that may go beyond the ambit of the law, right? Technically, what they're doing is legal. The problem is it shouldn't be legal because it's unsafe. And then C has to do with internal communications, right? If you go to your supervisor, you go to the board, you go to the CEO, you say, hey, look, they're making me do this and this and this. It's not right. It's unsafe. It's going to be a problem. So there's some recognition for the fact that if something is being done that's unsafe, the law may not, the law may be silent on it, but still it would be against public policy to terminate someone if he's talking to regulators about it. 20, as you'll see, really isolates violation of state and federal law regulation. So in other words, if the case is coming from the fact that a person refused to engage in activity as opposed to disclose to someone else, but he refused to engage in activity, you really do need to find a statutory or regulatory basis, or at the very least find some case law that identifies a public policy in order to fall under the ambit of the act. Okay, that's all I have. I could continue to talk, but that's my sheet.
It's
I
a
think
good-
we should probably. Oh no, we have a moderator. Go ahead.
One second, let me just get so thank you both so much for giving those talks. They were actually very informative and fantastic. And we're going to go to the chat where some people had some questions. I'm just going to go in order that the questions were asked. Judge Gubin asked, sorry, my computer just moved. Okay. Judge Gubin asked, how is productivity defined? And I believe that's to Ms. Goldman.
The standard productivity measure is you take the amount of output and you divide it by the labor that went into it, and that the costs of labor and other resources that went into it. And that's how productivity is typically measured by the Bureau of Labor Statistics. There's obviously some problems with that, because that would mean that you can increase productivity just by decreasing the cost of labor, and in service industries, sometimes to get better quality service, you need more people, which then would mean productivity goes down, even though you might be providing better service. So it is a very flawed measure, but it comes out of the industrial definition.
All right. And Sharon Eisman asked the next question. She is asking that should she assume that there were also large gender gap in wages as well, excuse me.
I think you're referring to when I talked about the difference in the gender occupations of operators and of customer service reps and of technicians, and absolutely. And it was always the argument of, especially the customer service reps, that their skill level was very high. They had to know a lot but it was emotional labor. You need to know how to interact with customers and to pick up on their needs and their emotions. And in general, in our society, those emotional laborers tend to be women, and that kind of skill tends to be underpaid. And the women always argued that they deserved to, the people in this occupation deserved to have their skills valued at the same kind of rate as the technical skills of a technician, which was about 20% higher in wages. And if you can remember back those who were around in the 1980s, there was a strong movement called pay equity. And the legal argument came out of our EEO laws. And the argument was that we need to look at and the skills, and so that if a librarian is making less than the I don't know, the electrician who works in the library, but the librarians are primarily women, and their kind of skills are different than the craft skills of the electricians. Let's have a different way of evaluating those jobs. And particularly in government, there was a lot of progress made for about 5 or 10 years in the early 1980s around pay equity, but that also kind of has lost steam legally and politically.
I can speak to that a little bit from the legal side.
Good.
Yeah, so on the legal side of things, once again, you start from the beginning, right? A company can kind of do what they want unless there's a law or a statute that says otherwise. And so here, when it comes to equal pay, you're going to be comparing people within a specific position, right? So if you have a bunch of people that are class, whatever the position is, let's call it statistician class 1, and the women are being paid differently than the men, obviously that's a problem. But if you have different different positions, statistician class 1, electrician class 2, whatever, so you wouldn't be comparing between those two positions in terms of a lawsuit. However, what that does get into is just simple gender discrimination, where if women are applying for these positions and they're not getting them, so there you would look at just the simple legal analysis is, are similarly situated employees being treated the same? Similarly situated almost always means within a specific job description. There are certain circumstances where you can expand that definition if it's relevant to the case, but in general, similarly situated is going to be within a specific job description. So you can't hide the fact that people are similarly situated by calling them something else, but if they're basically doing the same job and the requirements are the same, so they're similarly situated. All right, fine. So if a bunch of people are applying to be electrician class 2, and the only people that you're hiring are men, so obviously that's going to be a problem if folks are similarly situated, meaning they have the same they have the same qualifications. Those are hard to prove, because really what you have to demonstrate is that your person should have gotten the job, and the only reason they didn't is because of the fact that they're a woman, or they're whatever the classification is that you're focusing on. Statistical analysis can get you only so far in terms of the evidence. You typically do need to also demonstrate that the person would have gotten the job, other than the fact that they're whatever the protected class is.
Okay, thank you. Bob Blinick asked, or stated he's seen that many companies have outsourced their call centers to locations in other countries. As clients with limited choice, what can we do to encourage in-country hiring?
I don't have a very good answer to that. CWA and other unions have been promoting call center bills, which at least would require that if you ask where the person is located, they have to tell you. I personally do not have a problem with the fact that there are working people who are trying to make a living and they live in the Philippines or India or wherever. The problem is that they tend to live in places where very autocratic regimes, and the opportunity for them to improve their working conditions and their labor standards are met with very violent resistance by not only their employers, but the military. So what we really have been doing as a union is forming relationships with the very nascent and weak worker organizations of call center workers in the Philippines, which is the largest place for offshoring. About 1 million people in the Philippines work as call center workers. If you're doing technical support, it tends to be to India, but it's really to the Philippines if it's questions about your bills or airlines or whatever. And we're trying to assist them so that they can raise their living standards, and therefore the financial advantage to the company of offshoring is lessened. But that's a long term. Now, as an individual, if you feel like the person who is talking to you is not well trained, I sometimes ask, can I be transferred? And you can do that, but be cautious when you're then given a follow-up survey, because often the reason that you didn't get a good service is not because the individual had a problem, it's because of the systems. But if you're pissed, which I often am, and you say, well, I got bad service, that's going to mean it was a black mark on that individual, even though it may or may not be her issue. So it's a challenge right now. How do we, and I call this part of the consequences of deregulation and the race to the bottom.
It's funny. I came of age politically in the 90s, and it was you get to see the world change a number of times over the course of a lifetime, I suppose. I remember when tariffs were they tended to be a Democratic Party issue. Today, of course, they're a Republican Party issue. And I think it was 92 was the Republican Party had to deal with, you know, some lunatic Pat Buchanan running for president on a platform of tariffs. And people weren't happy about that because that wasn't really the platform. And the world has changed a lot, and it'll continue to change.
I guess this is, since I'm the moderator, I'm gonna go into that. So I think years ago there was it's not recently, probably in the past like 10, 15 years, there was a law that was enacted where it's illegal it's basically for sex trafficking of, you know, the Americans going to other countries for sex trafficking and taking part with like the raping of children. Do either of you think it would be possible that where we could make similar laws where American companies would still have to make sure that American laws are followed, like minimum wage and things like that in call centers that may be somewhere else? Do you see what I'm saying, or is that too confusing?
Yeah, I'm, you know, look, I don't want to get on I like to come and provide information rather than get on a soapbox, but yeah, sure. The soapbox speech is that labor's been behind, been a huge push behind this idea of child labor laws in foreign countries and child labor in foreign countries and conditions in foreign countries, particularly because, you know, it's very expensive to employ Americans. And so it sometimes is easier just to employ folks somewhere else. And so then the big issue becomes, and, you know, I'm not accusing anyone of being opportunistic, but certainly the idea of promoting that type of thing, let's make sure that people in the Philippines and make sure that people in India are being treated the same way that American workers are, in years to the benefit of folks in labor in America. It's another way of creating tariffs, right? Make it more expensive to ship things from overseas. Is it possible to do that? Sure, but it realistically speaking isn't going to happen because there is, you know, there are good reasons for the way things are. One of them is it's going to make everything, well, because the simple thing is it wouldn't be possible really to employ someone in, let's just say, India in the present day along the same legal framework as you know, as an American. It just wouldn't be possible. And so what you would really be doing in effect is you'd be saying Americans can't employ anyone in India. They have to be employed here in America. And so everything gets much more expensive. That's the simple answer to that.
Okay, our next question.
Can I just quickly respond to what you're saying? When we negotiate trade agreements, it gives an opportunity not to say, here's what your wage rates have to be, but it gives an opportunity to say, in exchange for opening up trade, for example, when NAFTA was renegotiated, actually under the Trump administration, what can be some environmental protections? What can be work and safety protections? What can be a range of other protections so that those kinds of rules that we might have in our country that raise the cost of production or of providing services also are part of an agreement that raise those standards in the other countries. And in terms of workers, I don't think you can mandate a wage rate in another country, but you can, again, negotiate provisions which give workers in those countries the opportunity for collective organization, which is empowerment. And it's democracy as well as workplace empowerment. And there are examples, good examples, in which either bilateral or multilateral trade agreements have included those kinds of provisions.
So,
Yeah, I think you could come up with, I think you could, technically speaking, right, legally speaking, with the current legal framework we have in America, could a law be passed requiring American firms that employ foreign workers, meaning in a foreign country, not in America, that employ foreign workers to follow American labor laws? Sure. It's it's not going to happen, but yeah, I don't think there's anything in the law that stops that from happening. I just think
I'd rather, in some cases, I'd rather them follow the European laws. I don't want them following, our labor laws are very, very weak. You go to Sweden, you go to Germany, the protections for workers and the kinds of issues that unions can negotiate over are much, much broader. So I don't elevate American labor law as the model.
yeah, I was just responding to the question.
Yes.
I don't think
I
that was
wasn't
the issue.
suggesting anything. I wasn't suggesting a public policy.
All right, so the next question is from Sharon Eisman, who said that I assume at some point the organizers of the unions and the unions as well decided to hire lawyers to represent them in protection of their organizing and thereafter including their demands presented to the heads of companies. Did that shift make a big difference?
I like the question because I skimmed over a lot of things. Most national unions and local unions have lawyers on their staff. So there are lawyers who are ensuring that if there's a breach of labor law or other kind of laws that the adjudication enforcement happens. But within labor law, our current National Labor Relations Act, they're so weak that as you go through the legal process, the companies will appeal. In the case that I was giving, the appeals went all the way up to the DC Circuit. That can take 3 or 4 years. And if you happen to win, all that has to be done is that the workers who lost their jobs or were illegally fired have to be paid the back wages, subtracting out any other work that they've been doing during those 2, 3, 4, 5 years because they had to make a living. So there is really no disincentive in our labor laws for violating the law. Companies can delay. And you need to, what most unions have learned is, yes, you need to take the legal approach, but you also have to mobilize public opinion, and you have to make this a community issue.
It looks like I think the last, I believe it's more of a statement than a question. Chuck Aaron said that Florida is proposing.
I'm sorry, Sylvie, did you
Yeah.
skip? Pam had a question.
Oh, I'm sorry. Thank you, thank you. I'm sorry. I'm sorry, Miss Gellin. Pamela Gellin, is asking Miss Goldman, why did the companies at one point decide to be neutral and let the workers decide whether they wanted a union? Is there a recognized benefit to the company? It's hard to believe they did it because they thought it was the right thing to do.
That's a really good question. And the case study that I gave, it took 5 years. Workers were organizing. They were filing unfair labor practice cases as well. But in this case, the union was still strong. And in the case that I was talking about, this company decided that they could live with the union. Now, remember, in the Bell system, there was also a great sense of Bell system family and people who had been hired in as operators or technicians often rose in the management. At that point, the CEO of Southwestern Bell had once started his career as a union technician. So it was a different kind of culture too. But often what happens is a company will discover it just is not worth the loss of public opinion, or that there's too much disruption among their own workers, that they'd rather figure out a way in which to have a union that can address the problems. Let's talk right now about what's going on with Starbucks. About 600 Starbucks, various coffee shops, have voted to have a union. There are thousands more, but quite a number. And Starbucks prides itself as being a progressive company. And the fact, as more and more people began to learn what they were doing to block their employees' right to form a union, this began to besmirch Starbucks' progressive image. And so Starbucks actually came to the union and said, can we work something out? Now they're still negotiating, and some people feel like it's going to be a lot tougher under the Trump administration because there's a lot of motivation for companies not to bargain an agreement. But about a year and a half ago, it seemed like they were backing off from their anti-union stance because of that public image. So there's a variety of different things that can be done. Hotel workers have used this technique of getting public pressure so that some of the big hotels will back off from their anti-union stance. The service employees have used this to get building owners to agree to be neutral when their cleaners, their janitors choose to unionize. So increasingly, this is a tactic that's being used. But the general political environment has an influence on whether that can be more or less successful. But thank you. That's a really, really important question.
The next, I guess it's more of a, like I said, a statement that Florida is proposing to drop the age to 14 to replace all the deported workers, which I think is just a bill that's being proposed in the state of Florida. And then the next is Judge Michael Strom. I've seen many cases of awful work conditions that would not reach fine attorneys like John Lubin. In my experience, working on cases involving severe injuries or death of workers at fabrication plants in the Chicago area, the owners readily praise hiring illegal immigrants who do not complain about dangerous conditions and don't make WC complaints, are not union members. And one client even advised, I wish I could have all illegals.
So the Fair Labor Standards Act, for example, specifically the case law and certainly in the Northern District, and I think it's based on Seventh Circuit precedent, maybe even national, doesn't allow you to ask for, I mean, it's something that would seem to be amazingly probative in a Fair Labor Standards Act case, your tax records, because tax records can be used to discriminate against people who are not legally in the country. Just because you're not legally in the country doesn't mean you're not entitled, under the law, it doesn't mean you're not entitled to the protections of the Fair Labor Standards Act. So they go there's a lot of protections for folks who are not legally in the country, who are not legally working, even within the Fair Labor Standards Act, so that they can file Fair Labor Standards Act claims and they're not worried about their status being discovered. I have no idea, if anyone is not combing the records in the current administration trying to figure out who's filing these claims. I haven't heard anything like that. But I know that, and it came as a shock to me once because I've been on both sides of Fair Labor Standards Act. And the last time I represented an employer, I wasn't aware of this. And so I said, do you file taxes? And the plaintiff's attorney, kind of gave me a hard time. Like, hey, you can't ask that. And I said, let's go off the record. And I said, I don't know, I can't ask that. Explain this to me. And he explained it to me. And then we went back on the record. And I said, all right, thank you for the free education. I'm going to withdraw my question about the tax records. Yeah, so there's, I don't know. That's the only time I've ever encountered it. But I'm sure that's a similar thing is in place with a lot of laws having to do with employees and employers. Yeah, the law really protects people who are not legally here, the way just like it protects people who are legally here.
Maybe Michael or somebody else who has more experience with this, as you can tell, I'm a labor historian and a union researcher, not a lawyer. But my understanding is that under the Biden administration, something was passed that gave whistleblower protection to those who are in the country illegally who would be involved in some kind of a workplace action. But I don't know if that's been negated in executive order or just one knows that it won't be protected. But maybe somebody knows more about what I'm referring to.
I don't want to put Helen on the spot, but Helen, do you know the answer to that? I think, just a
Yeah,
second.
you need to let her. Yeah.
Yeah.
The technology strikes again.
Can you unmute Helen or?
Yeah, now I can. So I didn't hear the entire question. I think what you mentioned is something about the Whistleblower Act and folks able to report under the Whistleblower Act. And I don't know specifically about the Whistleblower Act specifically. So if Jonathan has specific information, he can respond. But my general knowledge and Jonathan's general knowledge of the laws equally applying to workers, whether they're here legally, illegally, is accurate, as I put in the chat, because I myself personally have represented injured workers in front of the Illinois Workers' Compensation Commission who were hurt on the job, and they are able to get their benefits. I've also had dealt with, I know I mentioned workers' comp, but it turns out in thinking about it also, I've also dealt with wage issues for folks who are here illegally. In fact, on the defense side, I've represented some restaurants in which their employees, not all of whom have, it turns out, have been in the United States legally or have the right to legally work in the United States, have filed wage claims for not being paid overtime under the Fair Labor Standards Act. And they brought, attorneys were happy to bring claims on behalf of these folks who are not here legally. And I was more than happy on behalf of my business clients to settle those claims. So I would think by analysis, the whistleblower would be the same thing. The only caveat I would give on whistleblower is that someone who doesn't work here legally might be apprehensive about bringing a whistleblower claim, because a whistleblower claim, as Jonathan talked about, you have to address the government. You have to complain to the government about, some kind of illegal conduct or whatnot that you're expected. And my educated guess is someone who is not here legally in the United States would not want to approach the government about problems in the workplace, at least directly in that kind of a context. So that's my 2 cents.
Thank you.
Well, it looks
I
like,
could answer that if somebody wants an answer.
oh, sure.
Go ahead.
I wrote the decision. It applies to all workers, whether they're documented, whether they're registered or whatever.
There you go.
Simple.
Thank you, Justice Gordon.
Justice Gordon, thank you so much.
You wrote what, can you just clarify
I
for
said
me?
I wrote the decision interpreting that
Interpreting
question,
what?
whether the action would apply to an undocumented person, it would, and they're fully protected under the law.
Thank
All right, well, that perfectly times the end of our CLE. Once again, I'd like to thank Debbie Goldman and Jonathan Lubin for their time and work putting this together. It was very informative, especially from somebody who does not know anything about labor law and the history of labor. Thank you all for joining us in our series. I believe hopefully Aviva can help me with the next events because I can't find it on the website.
Oh, I'm not allowed to vote on the poll.
No, don't touch the poll either. That will stop it. Wait, let me